going to talk about voluntary consent in this lecture. Now, we've studied contracts and we've talked about how they've come into existence, when a contract will not be enforced because it is illegal or against public policy, and how the law protects certain categories of people by allowing them to avoid their contracts. Now, this lecture is going to concern another category of relief from the enforcement of contracts. A contract may be unenforceable if the parties haven't genuinely assented to the terms. Now, in determining the genuineness of assent of the contracting parties, courts look at a party's objective intent. A court could find that genuineness of assent is lacking because of mistakes, misrepresentation, undue influence, or duress. In other words, because there's no true meeting of the minds. If the law were to enforce contracts not genuinely assented to by the contracting parties, then injustice would result. So we're going to learn about the differences between mistakes of fact and mistakes of value or quality. We're going to list the elements of fraudulent misrepresentation, and we're going to compare the misrepresentation of a material fact and then what the misrepresentation of law is. And then we're going to recognize the differences between undue influence and duress. There is a difference between mistake of value, such as believing something will be worth more than it ultimately proves to be, and then mistakes of facts, which would be believing something is something other than what it is. Only on a mistake of fact can a contract be avoided. A unilateral mistake occurs when one party is mistaken. So generally, the mistaken party has no right to relief, but there are two exceptions. The rule is not applied if the other party knew or should have known that a mistake was made. Also, some states will not enforce or may reform a contract in which an error was due to a significant mathematical mistake and it was done inadvertently and without gross negligence, such as a typo error. A bilateral mistake is when parties to both sides of the contract are mistaken as to the same material fact. Either party then can rescind the contract at any time. When a mistake concerns the latter market value of the object of the contract, normally either party can enforce the contract. Here's an example. This individual, Wishloss, bought a shipment of cotton from Raffles to arrive via Peerless from Bombay. Peerless is the boat. Wishloss expected the goods to be shipped on the Peerless sailing from Bombay in October. Well, Raffles expected to ship the goods on another Peerless, which sailed in December. When the goods arrived, Raffles tried to deliver them, but Wishloss refused to accept them. Did the two have a binding contract? No, they didn't. There was no binding contract because each party had attached a different meaning to the essential term. The mistake was mutual, based on reasonable assumptions on the part of both parties. When two parties contract under a mistaken but reasonable belief that a certain fact is true from an objective point of view, neither will be bound to the contract. Now, suppose that although there are two ships called Peerless sailing from Bombay in different months, both parties intend the same Peerless. Do the parties then have a binding contract? They do. If both parties intend the same Peerless, they're bound to the contract. In that circumstance, it makes no difference whether there are two ships called Peerless or whether the parties are aware of both ships. There's no mistake. Imagine that although there are two ships called Peerless sailing from Bombay in different months, Raffles knows that Wishloss means the Peerless sailing in October, and Wishloss does not know that there's another Peerless. Do they have a binding agreement? If so, is the contract for the sale of goods on the Peerless sailing in October? Yes and yes. If under these circumstances Raffles makes the contract intending not to perform it, then Wishloss can avoid the contract on grounds of misrepresentation. Fraud affects the genuineness of the defrauded party's consent to the contract. Normally, the innocent party can either rescind the contract or be restored to his or her original position, or enforce the contract and seek damages for any injuries. The elements are misrepresentation of a material fact. Number 2, intent to deceive. The innocent party's justifiable reliance on the misrepresentation, and be able to collect damages to the innocent party's injury. Now, misrepresentation can occur through words or conduct, including concealment. Misrepresentation must involve a material fact. Representations of future facts, such as this land will be worth twice as much next year, statements of opinion, such as this car will last for years, and sales of puffery are not considered fraud. An expert's statement of opinion to a layperson is treated as fact. In a case of contract fraud, this may entitle the innocent party to rescission or reformation. Misrepresentation can occur by denying or concealing a fact material to a contract. A misrepresentation of law, such as you can build anything you want here, does not entitle a party to relief from a contract unless the misrepresenting party is in a profession known to require greater knowledge of the law than a layperson possesses. So, like for example, real estate brokers are expected to know about laws governing land sales and use, where the average person might not. Ordinarily, a party to a contract can keep silent without liability unless a serious potential problem or latent defect, such as a crack in the building's foundation, is known to the seller but cannot reasonably be suspected by the buyer. Failure to disclose may constitute fraud in a fiduciary relationship. Here is a good illustration of what summarizes the elements of misrepresentation. Was there a misrepresentation of a material fact? Now, the misrepresentation may take the form of words or actions, but it must be a statement of fact, not of opinion. Then, if it's no, then it could be rescinded. If it's yes, we're going to move on. Did the misrepresenting party have an intent to deceive? Well, the misrepresenting party must know the misrepresented fact is not stated, must believe that the statement is not true, must make a statement recklessly without regard to the truth. Moving on, if it's no, then it could be rescinded. Yes, we move on. Did the deceived party justifiably rely on the misrepresentation? So the deceived party must have a justifiable reason for relying on that misrepresentation, must have been induced to enter the contract by the misrepresentation, and must not have known the true facts. So moving on, did the deceived party suffer an injury? If it's no, then in most courts the contract would be rescinded. If it's yes, damages may be recovered. Now, the measure of damages is the property's value, had it been delivered as represented, less the actual price paid. Punitive damages may also be rewarded in certain situations. So, when an action is equivalent to an assertion, such as concealment, is the action intended or known to be likely to prevent another from learning a fact, is equivalent to an assertion that the fact does not exist. Now, concealment is an affirmative act intended or known to be likely to keep another from learning of a fact of which he would otherwise have learned. Such affirmative actions always equivalent to a misrepresentation and has any effect that a representation would have been known, and as a result of that, they wouldn't have agreed to it. Now, in this situation, we're going to look at some examples regarding concealment. This concealment is applied in two situations, although it's not just limited to the two I'm going to offer you. In this first one, a party actively hides something from the other, as when the seller of a building paints over a defect. So A seeks to induce B to make a contract to buy his house he paints the basement floor in order to prevent B from discovering that the foundation's cracked. B is prevented from discovering the defect and makes the contract. The concealment is equivalent to an assertion that the foundation's not cracked, and this assertion is a misrepresentation. Now, whether the contract is voidable by B would be determined under guidelines called Restatement of Contracts, Section 160. Here's another one. In this one, A, seeking to induce B to make a contract to buy his house, convinces C, who, as A knows, is about to tell B that the foundation is cracked, to say nothing to B about the foundation. B is prevented from discovering the defect and makes the contract. A's conduct is equivalent to an assertion that the foundation is not cracked, and this assertion is also a misrepresentation. Scienter signifies an intent to deceive. Scienter exists if a party knows a fact is not stated, makes a statement that he or she believes not to be true, and makes a statement recklessly without regard to whether it is true or false, or says or implies that a statement is made on some basis such as personal knowledge or investigation when it is not. A deceived party must justifiably rely on the misrepresentation, and the misrepresentation must be an important factor in inducing the party to contract, though it need not be the sole factor. Reliance is not justified if the innocent party knows the truth or relies on obvious extravagant statements. A showing of injury may not be required in an action to rescind a contract, but in an action to recover damages, proof of injury is universally required. The measure of damages is ordinarily equal to what the value of the property would have been if it had been delivered as represented, less what it is actually worth. In actions based on fraud, courts often award punitive damages. Undue influence occurs in relationships in which one party can greatly influence another, thus overcoming the other's free will. A contract entered into under undue influence is voidable. Relationships in which one party may dominate another include fiduciary relationships, parent-child, trustee-beneficiary, and guardian-ward, for example. The party unduly influenced must not act out on his or her free will. Duress involves conduct of a coercive nature, such as forcing a party to contract by threatening the party with a wrongful act. Duress is a defense to the enforcement of a contract and a ground for rescission. Generally, the threatened act must be wrongful or illegal. Being in need is generally not a circumstance that will lead to a finding of duress unless the party exacting the price has created the need. So in finishing this lecture, I'd like to provide an example of an individual, David, who signs a contract with the Pings to purchase 10 acres of land in Idaho. If David believes that the land is really owned by the Pings when it actually belongs to the Smiths, a court may allow David to avoid the contract with the Pings because he made a mistake of fact. Now, suppose, however, that David instead makes a contract with the Smiths, who really do own the land. David believes he can then sell the land to Harcourt for a profit of 30%. Later he finds that Harcourt is not willing to pay what he expected. Can David escape his contractual obligations because of his mistaken expectation? Well, not likely, because David's overestimation of the land value and the idea that he believes Harcourt's desire to buy it is just really a risk of doing business for anyone. So a court's normally not going to provide relief for David under those circumstances.